Thank you, Your Honour. Venus initial S4 and on behalf of the defendant, Mr Hackman. My surname is spelled P for Peter, U R V for Victor, INAS, and I'm instructed today by Slater and Goldman Solicitors. Firstly, Your Honour, I just want to refer to some of the comments made by my learned friend. There was much talk about the facts of this case, facts to which we do not disagree. And also jurisdiction is enlivened in part by Schedule 2 of the Commonwealth Competition and Consumer Act 2010, also known as the ACL. And of course in this place we also are supported by the New South Wales Fair Trading Act 1987 Part 3. At times during this submission, Your Honour, I will be referring to some other cases, and they were pre-ACL, and they were made under the Commonwealth Trade Practices Act 1974 Section 52, which were the predecessor misrepresentation provisions. I'm going to be providing a two-part submission. Firstly, we're going to say that the plaintiff cannot make out a misrepresentation case against our client, and secondly, our cross-claim that if the first matter is upheld, we say also the second matter should similarly fall in the same category. My learned friend has referred, Your Honour, to a South Australian case from the South Australia District Court 2010, Classified Transport Proprietary Limited versus IDI Enterprises Proprietary Limited, judgment number 130. It's an unreported case, and we say that many of the things in that case are distinct from what we're hearing here today. Your Honour, in Classified Transport, the respondent skipped town. They did not acknowledge the vendor agreement, and they do not think that they have to repay any of the monies made under that arrangement. That is not the case for our client. Our client has always agreed that there would be a $900,000 vendor contract that he would honour, and it is in this place now to discuss that matter, but it may just be that the case has been brought for the wrong reason, Your Honour. This is not a misrepresentation case. Our client has said that he would always repay the $900,000. He's already made a $65,000 payment. The fact that his business has been strained by what were figures that were purported to allow him to make a profitable enterprise out of the business that was sold has not been the case. But at all times, we can distinguish this case from that in Classified Transport is our client has not walked away from the vendor contract. Your Honour, the plaintiff also makes quite a bit of another comment that was made around the time of agreement making about the sale of a Gold Coast apartment. And if I could just refer, Your Honour, to the statement that was actually made. I'm selling my Gold Coast apartment. Before I came to this place today to present this case, Your Honour, I had a discussion with my 19-year-old daughter, and I said to her, darling, if I was to say to you, I'm selling this house, would you think that meant I've been to a real estate agent and the house is already on the market, or that I'm going to do that? And my daughter said, the second, Dad. So the natural use of that language, I'm selling my Gold Coast apartment, means that he was intending to sell his Gold Coast apartment. He indeed went to a real estate agent and sought to do that. However, the real estate agent advised otherwise, and that project has been put back somewhat. Our client never agreed to a time frame on the sale of that apartment, and if it does sell, we of course will advise the plaintiff. Your Honour, there have been no misleading statements at all before the time of contract making, and the case cannot be made out by the plaintiff. I'd like to turn now, Your Honour, to the real misleading activity, and that is the cross-claim. The report supplied by the plaintiff to our client at the time of agreement making, called the inept report, that falsely claimed the business was worth a total of $5 million when it was not. And Your Honour, we say if a decision does need to be made today, it needs to be, or those provisions of the ACL will cut both ways. Your Honour, there is some authority around some of the provisions on reliance, and what we have is two cases, and they refer to a concept that complete reliance on a proposition is not required, it's only in part. And in our case, firstly, if I could take you, Your Honour, to a High Court of Australia 1984 judgment, Gould and Vagelis, it's Australian Law Report, volume 56, page 31, and High Court Justice Wilson at page 46, and it's in the parentheses in Roman numerals 4, said, "The representation need not be the sole inducement. It is sufficient so long as it plays some part, even if only a minor part, in the contribution to the formation of the contract." And of course, I can take you to the second authority, Your Honour, and that was a view supported by High Court Chief Justice Gleeson in 2001 in a case Henville and Walker, and it's Commonwealth Law Report, volume 206, starting page 459. The inept report I refer to was false and misleading on two counts. Firstly, it overvalued the property by $700,000, and secondly, the operating figures that were provided to my client were grossly inflated, and it was an overvaluation in Henville that proved misrepresentation in that case, and in Vagelis it was overinflated operating figures. On those things that were provided, our client was misled, and it wasn't just in part, it was actually quite substantial. Our client did rely on that inept report, and he took it to an advisor to seek an opinion, Mr. Goldchain. And in particular, when Mr. Goldchain gave the advice that it was a good deal, he said that, look, the market was a little bit deflated, however, it should return to the figures in the inept report. And as my client and his advisor were discussing those matters, the only thing they had to rely on was that inept report. It was the only way they could access particularly the operating figures. My learned friend has made another point, and that's a final comment made in the final stages of deal making, in that our client did not rely upon the inept report, but we think there's not too much in that, Your Honour. It was no disavowal of any sort. It was a typical comment made in the final stages of such a, well, it's quite a big deal. It's a $4 million deal between the parties, and of course our client is a shrewd businessman, and his comment that said he didn't rely on the report was nothing more than, I guess you could say, something to the tune of, "I want to offer you a lower price than you were asking." And it was a price to which both parties agreed. Your Honour, I think we've made out the claim, the cross-claim, that our client did rely upon the inept report. It was misleading, and it was misleading to a point that our client is now losing money, his loss, because he cannot make the repayments that he agreed to in the vendor contract. We say that this matter should be dismissed in its entirety, and in the alternative, there is, we say, no alternative than upholding the matter on both accounts, if Your Honour pleases.